Okay, well, Chris gets started on this one. What we're trying to do here is a little technology issue. We're trying to patch in our attorney for the Washington Raspberry Commission, who is based in Washington, D.C. This is a special project that he's not somebody we normally have on staff, but every once in a while, we recognize a need to be engaged in some trade debates and some trade issues. So we have used a King and Spalding. It's an international firm, but one of their big offices is in Washington, D.C., where they work with the International Trade Commission. We have used them several times in the past. Some of you Canadians and others here might remember 1980s. This firm represented the Raspberry Commission in a suit against Canada. That was resolved after a while. We also used them in the late 90s, early 2000s against a suit or anti-dumping suit against Chile. And for that went on for about 5-6 years. And now we have our fair trade people, our farmers came to us this spring and said, we have another evolving issue here that we have to address. So the goal is, are we going to get them in, Chris?
Yeah, let's go ahead and say, Frank, come on.
Okay. Hey, Steve, are you there?
Yes, I'm here. Hello, everyone. And
his name is Steve Jones. Actually, Steve worked on some of these cases in the past. He was a junior at the time. He is now one of the senior attorneys. And Steve will be representing us, but we don't think we're going to get him on audio, but we will certainly, we will on audio, but not video, right? We're going to get video too. All right, it's technology. We would hope we wanted to bring him out here, but for a 20-minute talk from Washington, D.C., that didn't make a whole lot of economic sense for anybody. So we're going to try to get him to, first of all, tell us what the issues are as he sees them. Hi, Steve. And then we'll patch him in and get some questions as well. Ready to go? Not quite. Okay. At least I see him.
Can you hear me?
I can. Okay.
All right. Terrific. Well, hello, everyone, and thank you, Henry, for that introduction. And thank you, Henry, and the board of the Washington Red Raspberry Commission for inviting me to speak with you today. As Henry said, we are working with the commission on a new project to evaluate the possibility of a new trade case against imports of frozen raspberries. The Washington Red Raspberry Commission and King and Spalding have a long history together. Henry alluded to part of that. My partner Joe Dorn, who retired from the firm 2 years ago, first started working with the Washington Red Raspberry Commission and the growers and processors out there in the early 1980s. He was not yet at King and Spalding at the time. He was at another law firm, but he filed a case and worked with the commission on an anti-dumping case against imports of straight pack from Canada in the early 80s. And then Henry mentioned again work that we did with the commission, which I was involved in. I joined the firm in 1995. I've been practicing international trade law now for about 27 years. Came to King and Spalding in 95 and started working with the Washington Red Raspberry Commission about 1997, which was my first trip out to Linden to meet with folks out there. But we filed an anti-dumping petition against imports of IQF raspberries from Chile in 2001, and that case was successful. We were able to get an order on imports of IQF raspberries, and that order was in effect for about 5 years. After that case ended, we worked with Henry and the commission off and on for a number of years, and then earlier this year, Henry asked me to speak with the board about the current situation, and I happened to be out in Washington on other business and was able to come and see Henry and some of the members of the board and members of the industry in early April, and we did a short evaluation at that time, a very kind of low scale work just to look at the import statistics, talk to the growers, find out what's going on, what the concerns are, and make a recommendation about what we thought, what type of case we thought might be appropriate for an evaluation. And that took place in April, and then just recently we learned, and we're very pleased to learn, that we've been chosen by the commission and by the state to help the commission evaluate a case. So we're right at the beginning of the process. Let me tell you a little bit about trade remedies. Those of you who have been involved in these cases before know probably more than you want to, but anti-dumping, countervailing duties, and another trade remedy what's called a safeguard. We've done anti-dumping cases with the commission in the past, and dumping is a situation where that examines the pricing of imports and imposes duties if the prices in the United States for the imported products are below the cost of production in the foreign country or below the price at which those products are sold in the foreign country. And that difference between the prices is what's called a dumping margin, and duties in that amount are imposed at the border to offset that margin and level the playing field so that domestic producers can compete fairly. That's one type of trade remedy. Another type is what's called countervailing duties. Countervailing duties are imposed to offset government subsidies, and governments will support industries in various ways, and if those subsidies are having an impact on trade and causing injury to a domestic industry, the amount of those subsidies can be offset by duties, and those are called countervailing duties. Dumping and countervailing duties, dumping and subsidies that are countervailable are unfair trade practices under U.S. and international law. In addition, there is a remedy that's called a safeguard that can be imposed if an industry is being injured by import competition, even if there is no unfair trade practice. It doesn't mean there may not be an unfair trade practice, but you don't have to allege an unfair trade practice and prove the existence of an unfair trade practice in order to get relief. What you need to show for relief under safeguard is that the imports are causing serious injury to the domestic industry. And then, unlike dumping and subsidies, and then if you are able to show injury, the case goes to the President of the United States, and the President will make a decision on whether relief should be imposed. So safeguard has some components like dumping and subsidies, the injury part of the determination. There has to be injury to the domestic industry, but there doesn't need to be an unfair trade practice. But again, there is a political element to this, in that a case needs to be made to the President that relief is necessary in order to mitigate and relieve the injury that the industry is experiencing. And back in April, as I mentioned, we looked at this and we talked to Henry and several folks in the industry, and we looked at the import statistics. We see imports coming in, unlike previous situations where the imports were predominantly coming in from one country. Back in the 80s, it was Canada. Back in the late 90s and early 2000s, it was primarily Chile that was the problem. We see today, and there is concern about imports from several places. A safeguard remedy can lead to what's called a global remedy. That is, it's not a country-specific remedy, it's potentially a remedy on all imports. In addition, we see not just imports of, say, straight pack, as the case in Canada, and not just IQF, as was the case in Chile, Well, we're seeing imports of all different kinds of frozen raspberries, IQF, straight pack, puree, lots of, every different type of frozen raspberry that there is seems to be coming into the United States. And if a dumping or subsidy remedy were to be sought under these circumstances, it might be difficult to obtain relief. It certainly would be very expensive because you have multiple countries where you'd have to allege the unfair trade practice and prove it. And you have different product forms, which in the past have been considered different, what's called like products, or different classes or kinds of merchandise. In a safeguard, and this is something we'll be looking at, but we believe that a safeguard case would be able to be filed and potentially provide relief against all types of frozen raspberries that are being imported into the United States. And like I said, it's a global remedy, so there wouldn't need to be a country-specific allegation and a country-specific case won against imports. So there are some pluses to safeguard. There are also some minuses. It's a more temporary type of relief than anti-dumping countervailing duty. There's no dumping and subsidies is 5 years and then can be continued pursuant to a case called a sunset review. A safeguard is a 3 to 4 year remedy, and then it's going to be lifted. But given all of the circumstances, we've recommended an evaluation of a potential safeguard case, and the commission and the board of the commission has accepted that recommendation and asked us to conduct an evaluation. As I mentioned, we had a brief phase 1 to this in the first part of this year. We're now going to be starting phase 2, which is the collection of data. In order to determine whether the industry is being injured by import competition, we need to see how the industry is doing. We need data on production and sales and profitability of the industry. And so we're going to be, with the commission's help and the board's help, we're going to be putting together and issuing to growers and grower processors a spreadsheet to complete with data on your performance over the last 5 years. We're going to be the base year for the analysis will be 2013, and we're going to be looking at 13, 14, 15, 16, and 17 as our 5-year period, which is what the International Trade Commission here in Washington would look at. And we have a really good staff of experienced people here that will be working on this and working with folks in the industry to report the data. We know it's not easy. It's a lot of work, but it's the only way that we can determine whether there is potentially an international trade case that can be filed and evaluate whether it's a strong case and whether it should be filed. And so we and the industry needs everyone's help, everyone's participation. The involvement of all growers and grower processors is absolutely essential here for us to have an evaluation and an aggregate data set that we can rely on, that we can use as the basis for making some really important decisions for the industry about what to do going forward. We're working on, as I said, we're working on the surveys right now. It looks as though those surveys will be going out before the holidays. And as I said, when they go out, there will be communication about them, instructions, and so on when those are sent out, and including contact people here at King & Spalding, myself and others, who will be available to help you and answer your questions. And Henry, I think that's it. That's what I have prepared. I know I didn't have a lot of time, but I'd be happy to answer any questions that anyone has. And thank you again for inviting me to speak to the industry today. And we, myself and everyone here at King & Spalding, really values our longstanding association with the raspberry industry, and we look forward to working with you again on this project. Thank you.
Thank you, Steve. Thank you, Steve. That's really what we needed. Can you hear us?
I can hear you, yes.
Hey, thanks. I think that's going to be it. Our time is pretty limited here, so we're not going to get into time questions. I'm just going to reiterate what you just said in terms of the survey is being worked on right now by King & Spalding and our Fair Trade Committee. By the way, that Fair Trade Committee is not a closed committee. If some of you feel like you'd like to be participating in that, give an input to that, please contact me or John Mayberry, our president. We are open to good ideas, but we're working through this pattern. We think a 3 to 4 month kind of process where we'll work on these surveys. You're going to need to get good data from our growers so that we can actually present that in a really logical way, and it has to be done so that everyone can answer these questions in the same way, so we don't have all scattered kind of data. So we're working hard to get a clear survey to people they can all understand. And then we're going to compare that to quotes and price quotes to, other people have seen from other countries and say, well, here's what other quotes are coming in at. Here's our cost of production. We need to prove injury and then take it to the next level. That decide whether or not we really want to file this case. And that's phase 3 of the process. So that's what we have in front of us. I think most of you know why we're doing this. Most of you have seen that we've got lower production in this country, frankly, even looks like lower imports at some point, and lower prices. Somehow that doesn't figure. We have to figure out what's going on here and why it is that where the prices are coming down for all of our products related to raspberries. So thank you again. We will be more in touch. So thank you, Steve. We'll catch you later. So let's give him at least a warm applause.
Thank you all very much. Thank you.
Thanks. We'll shut that down, and we have one more thing before the break. Lisa is on. Thanks.